You've just been arrested for a DUI in Indiana. Your mind is racing, you have a million questions. But one of the most pressing is my license suspended right now? And the answer is more complicated than you think. In the next few minutes, we'll break down exactly what happens to your driving privileges after a DUI arrest in Indiana. After a DUI arrest in Indiana, you're actually facing two separate and distinct driver's license suspensions. The first of which is an administrative suspension from the Bureau of Motor Vehicles. And this happens when you are arrested, not necessarily convicted. If you fail a chemical test, blood or breath, meaning your alcohol content is 0.08 or higher, the BMV will automatically suspend your driver's license for 180 days. This suspension can start as early as your first court date. Some judges and some counties like to jump the gun and do it even before then, although that's not very fair because how would you know if you did that before then? But that is reality we have to deal with here in Indiana. The second type of suspension is a court-ordered suspension, which happens if and when you are convicted of a DUI. And we'll get to that in one moment. Now you might be thinking to yourself, what if I just refuse the chemical test? In Indiana, that is a big mistake. Under Indiana's implied consent law, just by driving on the roads, you've already agreed to take a chemical test if an officer has probable cause for a DUI. If you refuse, the license suspension will be for 1 year for a first-time offender and 2 years if you have a prior DUI. And this is in addition to any suspension related to a DUI conviction, meaning it's on top of. Indiana has set up the refusal suspension so that the suspension is often longer and harsher than if you'd taken and failed the chemical test. Plus, at least here in central Indiana, if you refuse the certified chemical test, blood or breath, the officers can very easily apply for and get a warrant to draw your blood. Now let's talk about court-ordered driver's license suspension. This is the suspension that comes as part of your DUI conviction sentence if you are convicted of DUI. The length of the suspension can vary wildly depending on the specifics of your case. If it's a first-time offense, the court-ordered suspension can actually be 0 days up to 1 year if it's a misdemeanor. If it's a second offense, by law, the minimum suspension is 1 year. And that doesn't matter if the first one was 15 years ago, 7 years ago, 2 years ago. The minimum is 1 year. Now, it gets a little bit kind of crazy if there's a felony, because if there's a felony, well, the license suspension can match the maximum sentence. So if it's level 6 felony, the maximum time in jail is 2.5 years. Well, the license suspension can be 2.5 years. If it's level 5 felony, because something bad happened, license suspension can be up to 6 years, so on and so forth. The good news, if you want to call it that, is the administrative suspension that was imposed on your driver's license when you originally were arrested, well, you get credit for that during a court-ordered suspension. Now, the math can get a little bit tricky, but basically, if you go to trial and you lose and you get a 1-year license suspension, it's going to be 1 year minus the 180 days administrative suspension. If you plead guilty and you get a 90-day license suspension, well, whatever you've done for administratively, if it's been 180 days, you actually did more suspension than you needed to. So the administrative suspension counts towards court-ordered suspension. That's important for lots of reasons. You never want to forget about that. So if your license is suspended, are you completely out of luck? Not necessarily. Indiana allows for what's called specialized driving privileges, or SDPs for short. These used to be called hardship licenses, but that term is gone. Now it's all specialized driving privileges. Now, specialized driving privileges are not guaranteed, but a judge can grant them to allow you to drive for essential activities like going to and from work, school, medical appointments, childcare. In most cases, if you are granted specialized driving privileges, you will be required to have an ignition interlock device installed in your vehicle. Not always, but that's what lots of judges want, so they feel safe knowing that you're driving without alcohol in your system. It's also important to note that specialized driving privileges are discretionary, meaning a judge can say yes, judge can say no, and they can do so for almost any reason they want. You have some judges that say, hey, I'll give it for 0.08, 0.09, 0.10. No. We have some judges in the state, if you have prior DUIs, they're still going to grant it, but they're going to make you do that ignition interlock, and they might have you check in with them every so often. You have some judges that never grant it, but they say, hey, Mark, I'll cut you one better. I'll give you a trial in 90 days. I don't want a trial judge. I want to be able to have my clients drive to and from work. So it's discretionary. You're not guaranteed, but there are things that we can do now, earlier, to give you a better shot at getting a specialized driving privileges. And we understand how important it is for people to be able to drive. We don't live in New York or Chicago. We live in Indiana. have to be able to drive for the most part. Let's quickly recap. After a DUI arrest in Indiana, you're going to face a couple of different license suspensions. There's going to be an administrative license suspension for 180 days if, when you got arrested, chemical test results came back at 0.08 or greater. If you refuse the chemical test, well, that's going to create a 1-year license suspension if you have no priors, 2-year license suspension if you do have a prior DUI. Now, on top of all of that, if you go to trial and get convicted, or if you plead guilty, there's going to be a court-ordered suspension. Could be 0 if you have no prior DUIs, but it also could be as high as a maximum punishment in jail for that particular case. A misdemeanor, maximum time in jail is 1 year, maximum life suspension would be 1 year. Level 6 felony, maximum time in jail is 2.5 years, maximum life suspension, 2.5 years. You may qualify to get specialized driving privileges for both the administrative suspension and court-ordered suspension, but only if there is no refusal. Refusal kills specialized driving privileges, and that's by law. Specialized driving privileges are discretionary with the judge. The laws surrounding DUI and license suspensions are complex and can be overwhelming. If you've been arrested for DUI in Indiana, the most important thing you can do is speak with an experienced DUI attorney as soon as possible. They can help you understand your options and fight to protect your driving privileges. If you are facing DUI charges in the great state of Indiana, give me a call. Our phone number is 317-632-3642. It is a passion at this law firm to fight for those who have been accused of drunk driving. We'll talk about DUI defense all day. But most importantly, remember to always plead the fifth.